good afternoon, good evening, good morning, wherever you are. Thank you very, very much for joining us today for the JGLS Insolvency Law Public Lecture Series Part 2. This is a very exciting time, particularly because we are looking at a theory-practice combination, and I cannot be more than grateful for the support that we have from Insole International and the support internally from our Vice Chancellor to be able to allow this enabling initiative in putting this together. I'm Ishana and I'll be your discussant for this session later with Craig Montgomery, but without further ado, to deliver the welcome address and kickstart the series, I want to invite Professor Dr. C. Rajkumar, our founding Vice Chancellor. Please, over to you, Raj.
Thank you very much, Ishana. First of all, I would like to congratulate the wonderful faculty members we have, led by Ishana Tripathi, for conceiving this idea of the Insolvency Law Public Lecture Series. I want to particularly thank Insole International and its CEO, Jason Baxter, for your support. In fact, I had the privilege to know about Insole International many years ago when one of our very dear friends, Honorable Justice Arjun Sikri, who used to be in the Indian Supreme Court and now also is associated with the Singapore Commercial Court. He has been very actively involved in the past, at least with Insole International, and he introduced me to this organization itself. I'm very happy that we are doing this lecture series. I want to once again thank Craig Montgomery, who is a partner at Freshfields Law Firm, for accepting to deliver this lecture on cross-border insolvency in the UK response and aviation sector case study. It's wonderful to also engage in this conversation. This last few weeks have been quite exciting for us. Jindal Global Law School has been ranked India's #1 law school and one of the top 76th law schools in the world by the QS World University Rankings, whose rankings were released just a few weeks ago. So I'm very delighted that we continue to develop this intellectually vibrant culture in which our students and our faculty members are exposed to new ideas, including thought leadership on a number of areas. In fact, I also appreciate what Ishana has done, because one of the things that we don't do enough and we need to do more is to be able to work with organizations such as Insole International and bringing in law firms such as Freshfields as a part of this conversation. This kind of an engagement led by academic institutions but supported by organizations such as Insole International will help students in ways that we have not sufficiently recognized in the past. I would like to take this opportunity to let you know that Jindal Global Law School and OP Jindal Global University is fully supportive of this endeavor. I can only hope that this lecture and many more lectures that are going to come in the series will be of immense benefit to the students. As much as we are all getting used to the online ecosystem that we have evolved, I would like to hope that sooner than later, we will be in a position to welcome both Jason and Craig to our campus and have this conversation and the lecture in a more physical environment at our campus. Till such time, we should continue these conversations through this format. So once again, congratulations and thank you very much for being part of this initiative. Without further ado, I am now going to call Jason Baxter, the Chief Executive Officer of Insole International, to deliver his inaugural address.
Thank you, Vice Chancellor. I'd like to begin by saying how much of a pleasure it is personally to be asked to speak at the commencement of the Jindal Global Law School Insolvency Law Lecture Series 2. The Vice Chancellor in his address provided you with some information on Insole International, but I wish to take this opportunity to add some more description about the organisation, its membership, stakeholders, and initiatives and activities that it engages in. I'll speak to you about some of our recent initiatives, our plans for the future, and finally, I will introduce today's guest speaker. So the origins of Insole International date back to the early 1980s, when it was felt that with many practitioners dealing with insolvencies and bankruptcies that had an international perspective, there was a need for an organisation that would promote cross-border work, facilitating the sharing of ideas from practitioners working across the globe. The organisation is incorporated in the United Kingdom and headquartered in London, comprising a small number of employees. In 2019, though, we opened a satellite office in Singapore, which I will elaborate on later. Now, as the Vice-Chancellor said, Insole's membership comprises just under 10,000 members who have either approached or joined Insole directly, or as is more commonly the case, have joined through a membership of a local membership body, that it itself is a member of Insole International. Details of these local membership associations, of which there are currently 42, can be found on the Insole website. And if you choose to investigate further, you will see that there is representation from all over the world. In fact, our members are spread across 104 countries, forming what I would say is a truly international and connected network. Insole's members generally have a legal or accountancy background, specialising in turnaround and insolvency. From country to country, the balance varies, but at a macro level, this balance between the legal and accountancy fraternity is about a 50-50 split. In addition to lawyers and accountants, we have within our membership senior judges, well-known academics, regulators, and lenders. These professionals also work with us as ancillary groups, playing an invaluable role within Insole and providing valuable forums for discussion of mutual problems. In the pre-COVID world, these groups would meet at our annual conferences or where we'd schedule a seminar. Over the last 12 months, with travel restrictions impacting on everyone, we have successfully maintained these meetings in an online fashion. So we've definitely kept up the traction there. I'm very proud of that. Another group that falls within the Insole umbrella is our Group of 36, commonly known as the G36. And there's more details on that on the website. But this group comprises a number of corporate members, including accounting firms, law firms, and barristers' chambers. It was set up 20 years ago, and the firms within this group have committed to supporting Insole with its global initiatives. Initiatives that include areas such as judicial training or practitioner training, as well as the outreach work which we do throughout the world. Now, going back to 2016, Insole embarked upon a strategic review with a task force launched and a series of targets drawn up in 2017 for implementation by this year, 2021. A fundamental aspect of this work was the clarifying of Insole's vision and purpose and ensuring that that continued to be relevant in the modern age. And I'd like to just take some time here to address this. The Insole International is the global association for restructuring and insolvency professionals, influencing global restructuring and insolvency practice and policy, and supported by a membership who share with us a global perspective. We are known as the foremost international organisation that is the knowledge sharing platform for insolvency and restructuring professionals around the world. And we do this in many ways, through our annual conference, one-day seminars, technical publications, and various educational and training initiatives. I will highlight some of these later. Through these initiatives, our members also make long-lasting connections with like-minded practitioners across the world. An organisation that encourages and facilitates great networking opportunities. Quite clearly, a dynamic global economy needs dynamic global restructuring and insolvency solutions. And while some jurisdictions are highly sophisticated and experienced in their use of restructuring and insolvency systems, others are at the outset of their journey. For Insole, it is not enough to focus on the smaller number of jurisdictions when there are so many that need help. It is necessary to approach this with a truly and genuinely global mindset. In a global economy where cross-border commercial transactions can occur with minimized risk and value protected as far as possible, is an ideal worth pursuing. We feel that very much. There is much to be accomplished and a clear focus is required. We believe it is the right thing to do for future generations. With respect to our purpose, We are a member-driven network, maximising global economic value by improving solutions to cross-border issues and advancing restructuring and insolvency systems through the deep expertise of our members. Insole International exists to support its members wherever they may be and in whatever role they perform within the restructuring and insolvency profession. We take a global view of membership and a global view of the value we can add for our members and the profession. Now, the what and how of International's activities constantly expands in response to our market, ever-changing market. In essence, it focuses on improving restructuring and insolvency solutions where cross-border issues dominate. Those activities often include sharing knowledge and ideas that will further commercial objectives, developing networking contacts through facilitating cross-border business opportunities, and helping support the global economy. Though we are very much aware that nationally based restructuring and insolvency issues are best handled by national level association and member groups. Importantly, we rely on the generous contribution of expertise and time from our membership and the aforementioned group of 36. This is the powerful engine room of the growth and impact we aspire to achieve in global restructuring and insolvency. As a result of the aforementioned strategic review and responding to the changing global landscape, Insole has in recent years enhanced its learning and education initiative. Our members have access to an impressive library of technical publications available on our website, and we are grateful to the practitioners and academics who have contributed to these over the years. One recent initiative that I would like to make special mention of is the COVID Guide, produced alongside the World Bank Group and currently going through its 4th iteration. This will include information and updates on how countries have responded to this crisis and will provide a focus on country-specific government support and insolvency legislation. Impressively, this update will include chapters covering around 80 countries, so a highly comprehensive project. While we often seek to educate and inform through our publications and seminars, conferences and webinars, Insole International launched an online cross-border insolvency course in 2019, known as the Insole Foundation course. A course such as this, which promotes remote learning, is consistent with Insole's ambitions to provide training and education that is not price prohibitive or dependent on the ability to travel. The Insole board and executive are committed to ensuring that Insole remains a credible global voice and is representative of its members. I mentioned that in 2019 we opened an office in Singapore, a very significant step for Insole, whose only presence had, until that time, been in London. The opening of the office will help to support the ambitious initiatives we have planned for the Asia Pacific region, which include enhancing our event program and producing bespoke training and education. Alongside Insole's Academic Steering Committee, we are committed to working with educational establishments throughout the world. We are this week currently hosting the Ian Fletcher International Insolvency Law Moot, which is in its 5th year and has attracted 16 international teams who are competing in front of the judiciary and practitioners. I was delighted to see that 3 Indian teams are taking part this year. In the last moot we held last year, OP Jindal University was a runner-up, losing to Singaporean team in the final. This indeed is a great achievement as the competition was very high. It's a fantastic event and we salute all that take part in it. Before I conclude, I would like to stress that we already work closely with the academic communities across the world. In some parts of the world, we have a stronger connection than in others, and we are working hard to bridge this gap and develop more and stronger connections where possible. For example, a recent initiative that we are developing is a student newsletter that we intend sending to universities across the globe. We would be very pleased to work with all of you in India. Therefore, please do reach out to us and get involved with our global initiatives. Everyone is welcome to work with Insole, whether you are a member or not, and I mean that sincerely. In our experience, we see that academics and practitioners can work closely together and learn from one another. Insole is a forum that nurtures this relationship, and this public lecture series, beginning today, is a good example of this. Returning to this week's Insolvency Law public lectures, It is a privilege for Insole International to have had the opportunity to assist in arranging for practitioners to address students and consider some relevant cross-border issues. I cannot stress enough the importance of providing a forum where students can learn from practitioners, and I look forward to seeing Insole work with the Jindal Global Law School and other educational establishments on future initiatives like this. Finally, I have not yet mentioned the Insole Fellows. I've spoken a lot about this various stakeholder groups, but I haven't mentioned Insole Fellows. Those who have completed Insole's Global Insolvency Practitioner course. Our Fellows are very much at the forefront of shaping the future of Insole. They sit on our committees, speak at our events, continually write for our publications, and are always keen to contribute to our educational initiatives. Over the next few days, you will hear from 5 of our Fellows who will provide an insight into their expertise and thoughts on an array of topics. It gives me great pleasure now to introduce Craig Montgomery, Insole Fellow and a partner in the London office of Freshfields, Brockhouse Derringer LLP. Craig has a broad practice advising on a range of matters, including contentious restructuring or insolvency issues. Especially complex matters in regulated industries involving cross-border issues. The who's who of legal has described Craig as a top-notch litigator, highly recommended by sources thanks to his deep knowledge of regulated industries and restructuring and insolvency proceedings. He indeed possesses a highly impressive resume. Please join me now in welcoming Craig. I thank you.
Thank you very much, Jason, and to Raj and Ishana and the Jindal Global Law School and Insole International for the invitation today. I'm delighted to be able to speak to you all this afternoon and to share a few insights into cross-border insolvency in practice. In that context, I'm focusing today on airlines because they are the paradigm global businesses with assets and liabilities around the globe, and for obvious reasons, given the COVID crisis that we're all facing, have been particularly impacted and are therefore particularly distressed and in need of restructuring solutions. I'm also going to be focusing primarily on English law because that's the system with which I'm most familiar, but also because English law is widely used in commercial arrangements that have little connection to England. And so restructuring and insolvency practitioners in England often have to deal with complex cross-border matters. England has a suite of very flexible restructuring tools that have been quite attractive over the years for lots of English and foreign companies to use. They include schemes of arrangement, which I believe you have in India. That's effectively a compromise that a company can enter into with its creditors. And if you can get 75% by value and a majority by number to vote in favor of and support the scheme, and you get it sanctioned by the court as fair, then it binds all of the creditors. And that is therefore a very powerful tool. And we also have, as of last year, a new tool called a restructuring plan, which is effectively a scheme plus. It has a lot of similar features with the scheme, but also allows cross-class cram down. So where you split creditors into classes and you need to get 75% of each class, with a restructuring plan, if you meet certain criteria, you can force a class to accept the plan even if they've not voted in favor of it. So that's a very powerful tool. And each of these have quite low jurisdictional thresholds. So you only need to have what's called a sufficient connection to England, which may be as little as the obligations being governed by English law, in order to be able to avail yourself of the scheme jurisdiction. And given how widely English law is used, as I've said, in financing arrangements and other contracts that don't have any connection otherwise to England, it's relatively easy for companies to avail themselves of that jurisdiction. Another attraction of doing your restructuring in England is our approach to recognition, which is actually quite conservative. And the starting point is what we call the Gibbs Rule, because it comes from a 19th century case called Gibbs. And the rule is that a foreign restructuring of English law debt will not be recognized under English law. So if you want an effective restructuring of an English law loan or other contract or debt, you have to do it under English law. Otherwise, it's not going to be recognized. And that is an attraction of people coming to England to restructure those liabilities rather than doing so locally. We also have treaties for cross-border recognition. We've implemented the UNCITRAL model law, with which many of you will be familiar, which doesn't require reciprocity. So we will in England recognise qualifying insolvency proceedings from any jurisdiction in the world where the debtor has their centre of main interests or an establishment. But it's not a it doesn't override the Gibbs Rule, so it's not a mechanism for recognizing those foreign restructurings. We also find that the schemes have been widely recognized under the UNCITRAL model law, particularly in the US under Chapter 15 of the US Bankruptcy Code, which is their implementation of the UNCITRAL model law. And so schemes have found effectiveness across borders in that way. We also used to be party to the European Insolvency regulation, but as you will no doubt know, the UK as of this year is no longer a member of the European Union, and the insolvency regulation no longer applies. And we can touch a bit on what the landscape of that is and Brexit later in the talk if we have time. Now, onto our case study for today, which is the airline case study, and I've shared that a single slide with you, which shows some of the outline of that. So it's a fairly simple structure, just so that we've got something we can talk about. I've chosen a Singaporean airline, a fictional airline called Air Singapore. So it's incorporated in Singapore. So clearly Singapore is going to be a very important jurisdiction when it comes to restructuring this airline. It has a holding company and then a sort of wealthy ultimate shareholder behind it. It has a fleet of aircraft which it doesn't own, and as is common in the industry, those aircraft are leased from international leasing companies, which could be incorporated all over the world. There are Korean and Japanese and Irish and US leasing companies, and the aircraft will generally be leased by an SPV, which will be incorporated somewhere like Ireland or the Cayman Islands or something like that. And then there will be a sort of shareholding head lessor. So this airline operates flights around Asia into Europe and the United States, so it does have connections to Europe and to the US, and it has offices in Singapore, in London, and in the US in Los Angeles. In terms of its debts, I've mentioned that the leases of the aircraft are governed by English law. It also has bonds which are governed by New York law, and a term loan from a syndicate of local banks in Asia, which is governed by Singapore law. In terms of the structure of the leases, the diagram on the right-hand side of the slide shows that the leases come from the head lessor into Air Singapore Leasing, which then subleases the aircraft to Air Singapore. And the leases are guaranteed by Air Singapore Holdings, which is the shareholder. And the subleases are security assigned to the head lessor. So some of that structuring we may want to get into when we get on to looking at particular questions. So we're going to do this in a Q&A format. So Ishana, what would you like to touch on first?
Thanks for that background, Craig. Now, one of the things that is very interesting about this lecture series, as you and I were talking about, is the airline sector and aviation, right? In general, we are doing a pre-post-COVID sense in terms of how the airline industry has been hit right now. But in India, we have seen two large-scale, meltdowns in the aviation sector prior to COVID, non-related to COVID. And during COVID, we're looking at a restructuring that is not happening in India, but it's actually happening in the Netherlands, which is also something that we're going to talk about. Now, the UK response to restructuring in the aviation sector has been very different, irrespective of pre and post-COVID. Like in India, it was winding up prior to 2016, and in post-2016, we're doing restructuring, which is not within our jurisdiction. So in this kind of different setup, what are the laws that are relevant in this particular fact pattern, and what are the challenges that are being faced in this fact pattern to secure a restructuring, and what are the different processes that you can use, because it is kind of fitting the process to the situation. So take us through that a little bit in the context of this case.
Yes, thanks. So you need to think, so effectively, if you're looking to restructure, so to find a non-terminal process, something other than a liquidation, where you can restructure these liabilities, reduce them to an affordable level, and bring the airline out the other side. And that's in everyone's interest, because if the airline goes bust, everyone will get a few cents in the dollar. Whereas if it can restructure and go forward and continue to operate, then the lessors and the banks and the bondholders are all going to be better off in the long term. So what laws do we need to consider? So we need to think about the governing law of the contract. So here we've got English law aircraft leases, we've got New York law bonds, and we've got Singapore law debt. And we want whatever we do to be effective under all of those laws to ensure that we don't have individual creditors going off and taking action which is detrimental to the creditors as a whole. Everybody needs to be bound in. At the same token, we've got location of assets. So where are the aircraft? Where are the offices with assets? Where does the company have bank accounts, etc.? And that's relevant because somebody who's disgruntled by the process may seek to go and take enforcement action in a different jurisdiction where you have assets and steal a march on the other creditors. So what can you do to prevent that and to hold the ring? And then finally, there's the place of incorporation. And in insolvency law, the place where the company is incorporated, where it has its center of main interest, is a very important jurisdiction and would likely be the place where a liquidation or a bankruptcy would take place. So that's going to be an important jurisdiction to look at as well. Now, basically, Air Singapore is going to have four options here. One, it could enter into consensual negotiations with all of its creditors and lead to a contractual agreement. So everybody agrees to take a haircut on what they're owed or the terms of their ongoing leases, and we sign up a big restructuring agreement or variations to all of the leases that everybody agrees with. Now that's great. A contractual solution is obviously, that's going to be binding because everybody's will consensually sign up to it. That's the best solution if you can get to it. You could look at local proceedings. So here in Singapore, you'd need to look at what's available in Singapore. Could you do a Singapore scheme of arrangement? Are there other equivalent processes that are available? You could look at a Chapter 11. So that's a process that's very commonly been used for airlines because it's very international and again, a very low jurisdictional threshold, and it's a very powerful tool. Or you could use a UK proceeding like a scheme of arrangement here because you've got the English law leases, you've got that connection to England. And a scheme is what we used in the recent restructuring of Malaysia Airlines, where we had English law leases and we used an English scheme of arrangement to restructure those leases and to reduce the rents to a market level. Now, one thing we need to be aware of in relation to the leases here is the effect of the Cape Town Convention. So there is an international treaty called the Cape Town Convention, which applies in relation to international interests in mobile equipment, including aircraft, engines, that sort of thing. And if the interest of the lessors here is registered, which it will be in the register of the Cape Town Convention, then various rules apply as to what you can and can't do under various laws in relation to those liabilities. In particular, if the company enters into an insolvency related event, then you can't modify the leases without the consent of everybody. So if a scheme of arrangement were an insolvency related proceeding, then you would need everybody's consent in order to vary the leases, which effectively takes away the benefit of using the scheme, the purpose of which is to cram down people who are not consenting. Now, the Malaysia Airlines scheme was groundbreaking in that respect because it was the court took the view there that schemes are not insolvency-related events for the purposes of the Cape Town Convention, and so that means that you can use schemes to modify leases without consent. You would also, as we did in Malaysia Airlines, structure the scheme in such a way that even if it is an insolvency-related proceeding, people are still acting with consent, because if you give people the option to take their aircraft back and they choose not to do so, then effectively they're consenting to the variation of the terms. And so that's kind of opened the gates now for more people to use the English jurisdiction to restructure. In terms of Chapter 11, the US has not implemented the Insolvency Protocol of the Cape Town Convention, so those are matters of domestic law. And you very commonly see in the US the approach to executory contracts, including leases, is a little bit different from a scheme. And what you would commonly do there is reject all of the leases so that you start with a blank slate, if you like, and negotiate terms with individual lessors for the basis on which they're going to be retained. So you see, quite a bit of cherry picking of assets effectively.
That's quite interesting, Craig, because we're looking at multiple processes being utilized in a more effective, efficient way. Now, I want to contextualize this to the Indian audience, because pre-2016, we had multiple winding up petitions which were consolidated and then heard, and there was a devaluation of different kinds of assets and security interest enforcement, etc., in India, which eventually led to liquidation being the method, but did not really turn into an efficient model. The last airline, which was Kingfisher Airlines, when it underwent liquidation, there was not enough money to recover, and ultimately it was a settlement which didn't even cover one class of creditors. So in terms of an efficiency model, what about liquidation in the UK? How often is that the result? And what happens to the assets in liquidation, if there are not, it is not restructuring or the other alternatives that you mentioned that are being used?
Yes, so there have been recent examples of airline insolvencies rather than restructurings, and that could be a liquidation or it could be an administration, which is also a typically fatal insolvency process, which the airlines go into. The experience is that it's hugely value destructive. It really, what it actually looks like depends a little bit on the jurisdiction. And focusing on England, the recent examples have been Monarch Airlines, Thomas Cook Airlines, and Flybe. And those have effectively just been wound up, and what value that can be realized for their assets has been realized. There's a big regulatory dimension to that. First, in the sense of, can you continue to fly once you're in liquidation or administration in order to keep the business going, so that you might be able to sell the business as a going concern, you'd be able to satisfy customer liabilities, you'd be able to keep the aircraft operating and your crews, all in jobs and employment. And different regulators will take different views on that. So in the UK, there is no example of an airline operating in administration or in liquidation. It's just the regulator wouldn't permit it, and the administrator, who has personal liability for any liabilities that he incurs, wouldn't do it as being sort of too risky to operate flights. But even if you're not operating flights, even if you're in sort of liquidation mode of realizing value for the assets, then the regulatory dimension is very important as well. Among the most valuable assets that an airline will have is its airport slots. Now, those are quite an esoteric asset, which is it's effectively a license to move aircraft around an airfield from the gate to the runway at a specified time. and they are issued by a public body called the Slot Coordinator, free of charge to airlines. But they're, in practice, if you want to operate at, say, London's Heathrow Airport, which is a heavily congested airport, you could go to the coordinator and say, can I have some slots? And they would say, no, all the slots have already been allocated to airlines. So what you need to do if you want to get a slot at Heathrow is reach a deal with another airline to exchange swaps or transfer slots and effectively pay a balancing payment. So effectively, it's a sale transaction for the slots, and individual pairs of slots can go for as much as £10 million. So they're very valuable assets, but they can only be held by airlines because they are a license to operate at an airfield. And so if you lose your operating license, which you might do on grounds of financial fitness, then you lose your slots. So a lot of the work that we've been doing in those cases I mentioned is actually a regulatory fight to maintain the operating license long enough in order to do a transaction on the slots. And because of the way in which the slots are allocated you have 2 seasons in the year, a summer season and a winter season. And so you need to usually hang on a couple of months until you get your slots for the next season, so that you can then sort of transfer them to the purchasing airline. So that's a bit of a sort of esoteric feature of those, but important feature of those insolvencies. If you compare that to the experience in other jurisdictions, even within Europe, where the rules are similar because it's all governed by a European Union regulation, and the UK, as of now, still operates effectively the same legislation, but it's interpreted very differently by the regulators. So if you look at Air Berlin in Germany, for example, when it went into an insolvency process a number of years ago, it continued to operate its flights and then sold its business to in various pieces to Niki and to EasyJet. And the German regulator was very supportive of Air Berlin continuing to operate in that way whilst being in an insolvency process, something that wouldn't be possible in England. If you look at Alitalia, another European carrier, that's effectively been in some form of insolvency process for about a decade, and the Italian regulator is happy for it to operate in that way. Closer to our example of Air Singapore, if you look at Malaysia Airlines, as I mentioned, they this year did a scheme of arrangement to restructure the debts within the airline, but they had another restructuring event in 2015 where what they actually did was set up a new airline and use a primary legislation, use an act of parliament to move assets and liabilities that were required into the new airline and leave behind all the sort of old legacy liabilities which were then liquidated. So that's an example of how you could use a local liquidation to effectively save the business, even if the corporate entity fails. So from an English perspective, it's not likely to be an attractive thing to do, but in other jurisdictions, it may be an approach.
That the grounding and repossession angle is quite interesting, Craig, because we've never, I think, at least the big airline insolvencies in India, we've always seen a grounding and a repossession to the lenders that is happening in most of the airline insolvency, because they were all insolvency cases. Now, to move away from liquidation and towards sort of more a commercial viability option, for us, at least as a jurisdiction, Jet Airways is probably going to be the first restructuring, right? That is happening presently in the Netherlands. But the UK has had a different perspective and a regime in terms of consensual restructurings. How does an airline negotiate a consensual restructuring? Because you rightly pointed out there are regulatory elements, there are different lender elements, and in our case study, there are different laws also that are involved. So there could be regulators across continents, actually. So how does that kind of work out?
Yes, I mean, you can obviously negotiate consensually, and if you can reach agreement with everybody then and document it, then that solves your financial problems. I guess there are two difficulties to it. One is being able to hold the ring while you do those negotiations. So even just opening those negotiations and saying to people, your lessors, for example, or your bondholders, I need to do some sort of restructuring, might be an event of default under those instruments. And if you're just consensually negotiating, you don't have the benefit of any sort of stay in order to do so. So people could go off and reclaim their aircraft, or start enforcement proceedings. Fortunately, at the moment, it's a bit of a hollow threat for lessors, for example, because they don't want their aircraft back in this market. There's zero chance of them being able to re-let it. So there's a sort of a mutual interest in reaching a deal whereby the airline can continue to operate, stay out of insolvency, and pay as much as it can in rent to the lessors and in financial repayments to the other creditors. I mean, in terms of so assuming therefore that people want to do a consensual restructuring, how do you structure that? And that's where the processes, the legal processes, actually form a useful backdrop to that. So even if your plan A is a consensual restructuring, your plan B might be something like a scheme of arrangement, which allows you to cram down a minority. So if you have one or two people holding out, you don't need their consent. You can use the scheme to do it. And it also, presents a timeline. I know I've booked a court date. I'm going to launch the scheme on this date. So that's the time frame for these negotiations to take place. And having that kind of framework is quite helpful for everybody, just to kind of bookend it. And then your plan C might be an insolvency. If you don't get to the 75%, if people just don't engage at all, you've got an insolvency. And you also will need to say to the court, if you're doing a scheme, what would happen if the scheme wasn't sanctioned? Because that's the benchmark against which the court will assess, is this a fair process? Because if you're saying everyone will get 4 cents in the dollar if we go into, if Air Singapore goes into a Singaporean liquidation, but they're going to get 50 cents on the dollar if they do this restructuring, then that's the sort of thing that sort of sets the benchmark for what is a fair process. And so it's all about sort of a balance of leverage of the different parties. What will the airline do if the creditors don't agree to the restructuring, and what could the creditors do? And the reason we've got in the case study this wealthy conglomerate as the shareholder is that that's going to be an important element of it as well. If your shareholder has deep pockets, then the creditors, the lessors and the bonds are going to say, well, it can't be the case that we take a massive haircut that allows Air Singapore to get through these difficulties and take to the skies again, generating profits, and that all goes to the benefit of this wealthy conglomerate. So you'd end up reaching a deal where either you do what's called a debt for equity, where the creditors take the equity in the restructured airline, or if the company needs immediate liquidity, then maybe the shareholder puts in new liquidity to effectively buy the equity that it will have in the restructured airline. So that'll be a big part of the discussion as well.
The shareholder element is a little different for us, Craig. And I think when you and I were talking about how third-party sales pan out and how promoters and related parties are viewed in different jurisdictions. Just a side question here. What is the involvement of promoters and related parties in the restructuring process, in the consensual restructuring process? Can they put up their own funds in the consensual restructuring negotiation framework, or is it necessarily creditor driven? Because that is a big contentious issue in India at the moment in terms of the restrictions that have been placed on restructuring within the insolvency metric.
Yes, for the for the consensual discussion and for a scheme of arrangement, it's very much debtor driven, and so you're looking at, you know, what do you need to offer to the creditors in order to get the creditors to agree to the restructuring, and the shareholders in this example will certainly have a place at that table, because the lessors and the bondholders and the banks will be wanting to gauge, well, is it really credible that this airline is going to go into insolvency? Is the shareholder really actually just going to put the money in anyway? And that's where the sort of Malaysian example that I gave from 2015, and that was actually the backdrop to the Malaysia Airlines scheme in 2021, was, you know, there was a credible plan B, which is, you know, you'll set up a different airline, and you know, the shareholder will fund that. So we don't need this company if people aren't going to agree to the restructuring. And so there's that credibility point, and then there's also how viable is the business plan. So if I agree now to, you know, a 40% haircut or whatever, how likely is it that you're going to be able to afford even that? If you say that you're on the verge of liquidation, show me your business plan that shows you returning to profitability and when I get repaid and how viable that is, so that I know you're not going to be back for a second bite of the cherry. And a big part of that is, where's your capital coming from, and is the shareholder going to put in more money? And if you end up in a Chapter 11, then DIP financing, debtor in possession financing, is a big part of those. And if you look at the companies that are in Chapter 11 at the moment, those, you know, the structuring of that DIP financing, which kind of goes in and then gets a super priority in the bankruptcy, is an important dimension. So yeah, in any case, a very important rule at the table.
Now, that allows us to segue into the question that is being raised even right now, where you have a common law jurisdiction where a court is sort of saying yes to a cross-border protocol for for insolvency in another jurisdiction. Now, in this example that we see on screen, how would a Singaporean airline, in your example, use a US or an English process to restructure? Is it common? Is it attractive? Or is it because they're both common law, all common law? What happens in the use of process, use of law aspect when you try to restructure across jurisdictions?
Yes, so there are lots of examples of airlines using restructuring tools outside of their jurisdiction of incorporation. So, you know, Chapter 11 in particular has a very low jurisdictional threshold. You just need, you know, some money in a lawyer's client account, or commonly people would take a lease on a small office or something like that. Any sort of assets in the US are sufficient to get you jurisdiction. And so you see at the moment, Avianca, Aeromexico, LATAM, they're not US airlines, but they're all in Chapter 11 at the moment. And the reason they want to use it is it's very powerful. I talked about how you can reject leases and therefore, you know, effectively have complete leverage over the lessors to say, well, you have to accept this deal, or I'm not going to take your aircraft anymore, so long as you make the terms sufficiently attractive that you can get the fleet that you need. The other important thing about Chapter 11 is a purported worldwide stay. So as a matter of US law, if you're in Chapter 11, nobody can take enforcement action against you anywhere in the world. Now, whether or not that's legally effective everywhere in the world, it has an awful lot of soft power, because it's to breach the stay would be a contempt of the US court. And so if you're subject to the jurisdiction of the US court, and a lot of banks and financial institutions will have branches there, or if any of your directors or shareholders are US people or ever want to visit the US, then you're going to want to comply with the order of the US court. So it's very powerful in that sense. The downside of it is it's very expensive. So even for, you know, relatively small airlines, you're looking at least sort of 25-30 million US dollars in professional fees just to do your Chapter 11 on the basis they're generally done. So so it is available to Air Singapore. It flies to the US. It has its office there in Los Angeles. and it has New York law debt. So there's lots of connections to the US. It might also look at a UK process. So the scheme or restructuring plan could be available to it as it was to Malaysia Airlines. And the big advantage there is this rule in Gibbs that because your leases are governed by English law, the scheme is the only effective way, unless you get everybody to sign up to new leases, is the only effective way to restructure them. It's also it's a bit more targeted than a Chapter 11 because a Chapter 11 is a full bankruptcy process, so all of your liabilities are subject to that. Whereas in a scheme, it's only those that you choose to put in the scheme, so only the leases, for example. So it might be that you reach agreement with your bondholders, there may be majority voting under the documents to restructure the bonds, that you reach agreement with your Asian banks bilaterally, and the only liabilities that you need to restructure are the leases. And so an English law scheme would be a good way of doing that because it's very targeted, it's not disruptive, and all of your local law contracts, such as your employees and pensions and all that sort of thing, are not going to be subject to the jurisdiction of a foreign court. And that might be particularly a concern if there's a sort of government connection in the shareholding or something like that. So in terms of it's a cheaper process because of that, but you do need this vote. So you need the 75% of the class to get it, and so it's more of a consensual process where you kind of effectively need to pre-pack an agreement with the majorities of people that you need, and then you go into the process. Now, if you can do a restructuring plan, then you might be able to use cross-class cram-down. At the moment, that's untested, and people would have arguments around the Cape Town Convention potentially in relation to a restructuring plan. But we may see that in a future case. Either way, there is jurisdiction here because Air Singapore has an office in London, and even just the English law debt would be a sufficient connection to be able to do a scheme in the English courts.
Now, Craig, in terms of the Gibbs rule, it's always an interesting thought process because you see the Singapore Court of Appeals has sort of criticized the Gibbs rule to a certain extent. And in general, as you have pointed out, it sort of leaves the insolvent company with the unfortunate dilemma of having to choose between remaining at the mercy of some creditors or bearing the costs of attaining a discharge in multiple jurisdictions. In this context, though, and in our case study, where do we sort of make certain the enforcement element of discharging from multiple jurisdictions, right? It segues into the next question that I have for you, which is how effective would local restructuring processes be, sure, where assets are worldwide and contracts are governed by different laws, but segueing from question number 3, with the Gibbs rule actually not being as effective across jurisdictions, how would the UK law or an English court sort of react to the possibility that in a restructuring, the cost of attaining a discharge might be higher than the cost of restructuring for the corporate debtor?
Yes, so I mean, the use of local processes and their effectiveness depends on a number of factors. One factor is what does the local process actually allow you to do? And we see a lot of airlines at the moment that are using various types of local processes, some of which are standard insolvency processes and some of which are bespoke arrangements for those airlines. So if you look at Thai Airways, South Africa and Virgin Australia, AirAsia X, they're all using local processes rather than what we might term international processes in the US and the UK. But they don't need to be standalone. You might have multiple processes. You might do things in parallel. You might use protocols to govern what the different restructuring or insolvency processes in different jurisdictions are going to cover. So in this case, you might have, if you needed to restructure the term loan, for example, the Singapore law term loan, then you might use a Singapore scheme for that. So as you say, I mean, Singapore is not a great fan of the Gibbs Rule, but in sort of neighboring Malaysia, for example, they do apply the Gibbs Rule. And so, you know, you might, if it was Malaysian law, you might want to use a Malaysian law scheme for that if you can't reach agreement with everybody, and then do an English scheme of the lease liabilities and the bonds, for example. Or you might have a Chapter 11 in parallel with some sort of Singaporean process, and that's where you might have a protocol, and they're commonly seen in those sorts of arrangements where you've got a Chapter 11, then a local process to deal with, you know, what are essentially local liabilities alongside, you know, whatever you can resolve consensually. Now, the issue with the Chapter 11 obviously is the English law leases and the Gibbs Rule. So you might, you know, theoretically need to do an English law scheme as well, just to deal with the leases. In practice, you probably don't need to do that, because as I said before, the soft power of the US court is such that whether or not legally you've achieved, you know, a restructuring, in practice you have, if none of your creditors are going to do anything that's inconsistent with the order of the US court, in case they're found in contempt there. But if you look at the AirAsia X example, you know, they're doing a Malaysia scheme, but they have lessors, you know, enforcing in England and getting orders of the English court that amounts have not been paid under leases and have to be paid, and they're entitled, there's an event of default, and then going back to get those orders recognized wherever there are assets. So, you know, maybe less concern about not complying with the Malaysia court than there would be about not complying with the US court. But it all really depends on, as I said before, where are your assets, which laws are governing the various things, and will they be recognized there, and what practically are the risks you face. And if you're working consensually with your lessors and they think they're getting the best deal that's reasonably available, then in practice they're not going to be running around trying to repossess their aircraft. And so you need to balance all of those different factors to get a practical way through.
Which brings us to our next very important question, Craig. We today as a jurisdiction in India are cross-border without recognition, and that's how I'd like to call it. We do not have a model law that is looking into cross-border frameworks, and oftentimes, particularly in the aviation sector, it is cross-border. You're not looking at, be it your hire purchase contracts, be it your leasing arrangements, it's all cross-border, right? So in this kind of context, how has the UK adopted the Untitled model law on cross-border insolvency? Does it help? And here I want to make a very stark distinction between enforcement and recognition as well, which will be the next question. But let's talk a little bit about the model law and how it kind of assists in the aviation sector, particularly where in this example, you're looking at assets worldwide, contracts governed by different laws. And there is definitely a law that you have, international instrument that you have as a jurisdiction accepted.
Yes, so the UK is party to the Untitled model law and has implemented it in the UK since 2006. It's, to some extent, it's helpful. It will give you a local stay. So the way it works is if you have a foreign insolvency proceeding in the place where the debtor, the airline in this case, has its center of main interest. So let's assume in the case of Air Singapore, it's Singapore. So if the debtor has its center of main interest in Singapore and is in a Singapore process, then those are entitled to recognition in the UK under the cross-border insolvency rules as foreign main proceedings. And if we had say they were doing a Chapter 11, and we know they've got an establishment in the US because they've got their place of business in Los Angeles, then they'd be entitled to recognition as foreign non-main proceedings because they've got an establishment there. But it only takes you so far. So what it gives you in the UK is it gives you a stay. So people can't take enforcement action against you that's inconsistent with the restructuring. And it gives the foreign representative, the office holder, so if it's a liquidator or other office holder, or if it's a some officer of the debtor in possession will have the authority in England to represent the company and to take actions in England that it could maybe take under local English insolvency law. So it's a powerful and useful tool, but what it doesn't do is allow recognition in England of foreign law judgments or restructurings, and it doesn't override the Gibbs Rule. So you can't do a Singaporean scheme of the English law leases and get the recognition under the Untitled model law to effectively vary those leases as a matter of English law. All it will give you is a local stay for a temporary period of time whilst you go through that process. So, a Singapore scheme or a Chapter 11 would not strictly be effective. Other jurisdictions take a different approach. So if you look at in the US, at Chapter 15 of the US Bankruptcy Code, which is their implementation of the Untitled model law, it's broader. You get the stay, which covers assets in the US, but also because they don't have the Gibbs Rule, in the example of Air Singapore, where they've got these New York law bonds, what the English court, if you're trying to do a scheme of the New York law bonds, the English court will ask, well, is this going to be substantially effective? Is this scheme going to be recognized in Singapore, where Air Singapore is incorporated, and in New York, which is the governing law of the bonds? And so because of Chapter 15, the US courts will recognize the effect of an English scheme, so long as there is a centre of main interest or establishment in the UK, which there is in the case of Air Singapore because they've got the office here, to restructure the New York law bonds. So it's a much more effective tool in the US than it is in the UK. Now, the Untitled has a solution to this, which is the model law on the recognition and enforcement of insolvency-related judgments, which may, if England adopted that, the UK adopted that, which would change that position probably by statute to mean that effectively the Gibbs Rule is overridden. But that model law hasn't yet been adopted anywhere. And in terms of whether the UK would be likely to adopt it, it doesn't seem to be in the interests of UK PLC to do away with the Gibbs Rule anytime soon, given that it drives so many restructurings to London.
Well, one of the things that has always been, that we've always looked at the UK, even at the US and Singapore, has also been the aspect of faster recognition, faster enforcement of proceedings, right? And in terms of business, I'm going to ask the controversial question. You are looking at the possibility of main proceedings, secondary proceedings, and the protection that the European insolvency regulation, now the recast, kind of offers, which the UK does not have anymore. In that context, do you think that there is going to be first a shift in the recognition, enforcement, sort of swiftness that is that the UK has generally had, and will it impact restructurings? In this instance, yes, we had Singapore and New York, but like if we switch it to say Germany or France, what would the position change in that context?
Yes, so I mean, in the European context, so now that we're outside of the European law regime, we're not parties to the European insolvency regulation, but the European insolvency regulation never applied to schemes anyway. What we relied on much more was the EU judgments regulation, so that provides for reciprocal recognition in Europe of judgments in civil and commercial matters. And that's a double-edged provision, because on one hand it governs jurisdiction, which courts within the EU have jurisdiction to hear civil and commercial cases, and also recognition of judgments. So in some ways you need to sort of walk a tightrope if you're the UK court seeking to restructure a German company or a Dutch company or a Spanish company, because you don't want to interpret the judgments regulation in such a way that you don't have jurisdiction, because there's, if there's no connection to the UK. But on the other hand, you want to be able to say the scheme is a judgment for these purposes, which is entitled to recognition around around Europe. And the English courts have walked that tightrope very, very deftly over the years. But it no longer applies. So where it's relevant is in two senses. One, as I said before, the English court needs to be satisfied that a scheme is going to be substantially effective. So if it's a German or Spanish airline seeking to restructure its English law leases, then you would need German or Spanish expert evidence to say that the scheme is going to be recognized. And you can't any longer rely on the judgments regulation as a means of doing that. But the insolvency regulation and the judgments regulation were only ever part of that picture. And an important aspect of the recognition is just a simple conflicts of laws one, which in the European Union is enshrined in the Rome I regulation on laws relating to contracts, where if the liabilities are governed by English law, and then the question of whether those debts are discharged and how they are, to what extent they're enforceable, is a matter of English law, and therefore, if the scheme has been done in England and is effective as a matter of English law, then in most countries they would look to English law to answer the question of whether the scheme is effective, whether or not the scheme is itself directly entitled to recognition. So that's usually enough for the English court to be persuaded that there is the substantial effect. The second question is whether in practice your expert's opinion is going to stack up, and if somebody tries to sue you in Germany or Spain, the scheme will be given effect to. And that's partly a question of those local law issues, but it's also the sort of soft power question of whether in practice an aircraft lessor or a bank or a bondholder is going to sue you in Germany or Spain, when that would be inconsistent with the English scheme and the moratorium that is applied under the English scheme. And in practice, that doesn't really happen. So the schemes are effective. In terms of your question about what's going to happen in the future, we don't have the instruments, the insolvency regulation and the judgments regulation anymore. And another factor is that a number of European countries are bringing in their own scheme-like restructuring processes. So there's a new one in the Netherlands and there's a new one in Germany. They will have different ambitions as to what they want to achieve with those. So the German regime seems to be directed really at restructuring sort of German debtors, whereas the Dutch, and I know you're speaking to Rob in one of the future lectures, so be interested to hear his views on this. But I think the Dutch do very much have an ambition to be, the new England in terms of everybody bringing their restructurings to the Netherlands and restructurings that don't have any connection to the Netherlands. But again, English law is a trump card here. So for so long as people are choosing English law to govern their debt and to govern their aircraft leases, then the Gibbs rule means that an English scheme is a very attractive way of restructuring it, and it's difficult to see how the Dutch scheme achieves that. Now, whether would we want to enter into a future treaty with the European Union to govern mutual recognition of insolvency proceedings and indeed civil and commercial judgments? Yes, it's possible, and I think the UK would definitely want one. I mean, we see ourselves as a centre both of commercial litigation and also of restructuring and insolvency. So the UK, I think, would definitely be keen to enter into that sort of treaty. And it also commercially makes sense for the EU to have a sort of seamless and efficient process for the recognition of judgments in relation to one of their largest trading partners and a big commercial centre that's just on their doorstep. But of course, these things aren't governed by what is rational and logical and makes economic sense. They're governed by politics. And the reality is that these things are not likely to be at the top of anyone's agenda anytime soon from a political perspective. And there will be, other things that get in the way, and so it's possible, but I suspect not in the immediate future.
which sort of brings me back to the sector that we're in, Craig, as a wrap to this lecture. So the aviation sector in general, as we started out as well, has been hit the most with respect to the pandemic, and we've seen a lot of restructurings, a lot of stake sellouts, etc., as a part of this. Now, pre-COVID, post-COVID, and after COVID, could you just give us a snapshot of how you have dealt with insolvencies, liquidations, and restructurings in these three pockets? And how has the COVID pandemic become sort of the median from a pre-post future perspective? And what is the future of this sector vis-a-vis business and restructurings?
So, I mean, airlines have typically as a sector not been the most creditworthy vehicles. It's a difficult business to make money in. It's very marginal. So there have always been, air carriers that have sort of failed along the way and have had to be restructured. And, we see that particularly in the US market, for example, where all the major carriers have been through consolidation, at least 2 Chapter 11s each over the years. The COVID crisis has been a quite extraordinary event for the sector, though, where effectively their revenue has just gone off the cliff, but they still have fixed liabilities in terms of debt servicing and paying rent on aircraft, etc. And the difficulty has been over the last sort of year that it's been difficult to judge where the bottom of that is. When will the sector recover? And there are a lot of different views about when that will be. IATA, the sort of international sort of trade body for airlines, says that they think we'll get back to 2019 levels only in 2024. So that's quite a long period before air travel picks up. And then there are other uncertainties around, whether, people have now, realized that they can communicate quite effectively like this. So, whereas I might have jumped on a plane to India to have this discussion with you, we can do it quite effectively now and much cheaper, over the video. So to what extent is business travel going to continue? To the extent it did in 2019. And couple with that with a sustainability agenda where companies and individuals are increasingly focusing on their environmental footprint, and aviation is clearly a luxury in that sense. How will that impact on the industry? So through the crisis, a lot of airlines have been looking at their balance sheets and have had to speak to their financiers and their lessors, but a lot of what's been agreed is temporary deferrals and also the forbearance on debt and power by the hour arrangements for aircraft. So you pay rent based on your actual usage of the aircraft rather than a fixed monthly rent. But those arrangements are building up, amounts that need to be paid even on a deferred basis. And at some point, even relatively healthy carriers are going to have to look at their balance sheets and restructure. And so we're seeing that. We're also seeing the lessors having to restructure, because obviously, while they will be very much involved in and negotiating a lot of these restructurings, even where a scheme is being used, they do it is a hit to their balance sheet, because their business model assumes a steady flow of income, whether from the airlines they've leased to or using their Cape Town rights to get their aircraft back and leasing it to someone else who will give them a steady rent on the aircraft, and therefore their financing and everything is predicated on having that income stream. If they don't have it, either because airlines go bust and the planes end up sitting in the desert, or because they have to agree to a restructuring and take a haircut of 30-40% on the rents, they in turn need to restructure the financings that lie behind the aircraft. So we're seeing an increasing amount of that, and I think that is now starting to ramp up now that, where vaccines are spreading, etc., people have got a better idea of what the recovery looks like, and therefore what the restructured airline needs to do in order to be sustainable. And I think we'll see that continue.
That's quite a positive note to end on then, Craig. And it's a huge takeaway, because one of the things that is fearful, and also I suppose the next step, particularly in the aviation sector for a jurisdiction like India, is privatization. And whether that is going to be the best step or not, or even in cases of insolvencies or banks which are, barely floating in the public sector, when you're looking at private players stepping in, there are huge dangers to that as well, and the lack of government control has always been a huge question in big ticket sectors, particularly transportation and aviation. So that's a very, sorry, go ahead.
So I was just going to comment on that, Ishana. It's interesting, and the way in which this COVID crisis is different from the financial crisis of a decade ago is that there's a huge amount of financial dry powder out there. There are lots of institutions that have a lot of cash that they want to invest. And so we do see, private equity investors looking around and saying, is this a good time actually to be buying into the airline sector? And in some ways, there hasn't been a better time since the 1940s to set up a new airline, because you can get aircraft very cheaply because nobody wants them. You don't have the sort of legacy debt issues of the established carriers. If airlines are going to the wall, you may find that you can get slots more easily than you could previously, and market share. And so people are looking at that very seriously, not only from a sort of ownership perspective in terms of that, but also in investments in those airlines that are perceived to be the winners. So if you look at EasyJet, for example, which is the biggest airline in the UK, it's a low-cost carrier. They recently issued some debt in the middle of the COVID crisis that was 5 times oversubscribed. So there's a huge amount of demand from investors for the right opportunities in this sector. And so the sort of developments you're talking about in India will be something to watch with great interest.
Absolutely correct, because the amalgamation of debt financing, debt restructuring, debt resolution, and also perhaps insolvency liquidation is all sort of put together into this one sector, and you can sort of watch the legal evolution and the business evolution together when you try to analyze this particular sector, which is why an aviation sector case study was such a crucial starting point for this particular lecture series, and you've done this fantastically for my students and the audience. Before I say thank yous to you and let you go, I want to tell the audience that we're all real-time responders of questions. So if you have any questions, please feel free to write to the speaker, please feel free to write to me, and we will respond to you via email. In the event that you want Craig to come back every year, please write to me only, and we will make all endeavors to make that happen. And hopefully we can, since the aviation sector is what we need to kind of save in some way for travel, I hope to have you back at the university here. I've done a little bit of paraphernalia to keep it as my background image, and hope to host you here and have you back again and again every year for every semester, Craig. Thank you so much for this insight. Thank you so much for this starting point. And for the audience, we're not done yet. We will get to Singapore tomorrow, and we'll talk about the Lehman Brothers crisis and restructuring from the Singaporean perspective, and come back to aviation on Saturday with Jet Airways. So thank you so much for listening. Thank you so much for this evening. And thank you very, very much, Craig Montgomery and Insole International, for making this happen and responding to my email. Thank you. And
thank you. My pleasure.
Have a good day. Bye-bye.